Good evening, everyone. I'm CA Gunjan Jain, moderator of this webinar. I believe all of you are in good health and keeping safe. Before starting today's session, I would like to appraise you about the 21st World Congress of Accountants, which is going to be held for the first time in India from the 18th to the 21st of November 2022. To know more about this, I would like to request the technical team to play a short informational video. Please watch this video and register yourself for it.
Geographically, the seventh largest country in the world, one of the oldest civilization, world's sixth largest economy, a global hub for innovation with one of the largest startup ecosystem. India, city of Mumbai on the western coast of Arabian Sea, among the most advanced and modern metropolises in the world, and the financial capital of India, gears up to host the most prestigious accountancy event of the world, 21st World Congress of Accountants from 18th to 21st November 2022, an event held every 4 years. The Olympic of Accountancy Profession. India hosts the event for the first time in 118 years since the WCOA came into being in 1904. Around 10,000 delegates expected to join virtually. More than 6,000 delegates from over 135 countries would congregate to exchange views at the world's most advanced Geo World Convention Center. The theme, Building Trust, Enabling Sustainability, will inspire the future of accountancy profession to create sustainable economies for the future.
The ICI is honored to be the host for this mega event, which will bring together the world's largest conglomeration of professional accountants, regulators, leaders, and visionaries to advance the cause of the global accountancy profession. Now, with the ease of travel restrictions across the world and the situation returning to normal, we are working towards creating a never before and a unique experience for all our delegates. The year 2022 marks the 75th year of India's independence, and the Government of India is celebrating the year in a big way to showcase the glorious history of India. World Congress of Accountants 2022 would also be celebrated as a mega event to showcase the important role that the accountancy profession has been playing in the economic and social development of the country.
A never before witnessed unique experience of learning future trends, emerging avenues, enhancing skill sets, networking, and to explore the incredible India awaits you.
We at ICAI are pleased to host you here in Mumbai, the financial capital of India, for the 21st World Congress of Accountants with the theme Building Trust, Enabling Sustainability from November 18 to 21, 2022, and give you a professionally enriching and personally rejuvenating experience. We are hopeful that the conference shall be stimulating and productive, and your stay in India will be a memorable experience. Once again, we invite you for this enthralling convergence in India, the land of multicultural, historical, and spiritual inheritance since centuries.
Insights from the stalwarts of the profession, international and national standard setters, regulators, and trendsetters will constitute the panel of speakers at WCOA 2022. Let your dream get bigger. Come, be a part of this mega celebration. For registration and sponsorship opportunities, contact. Organized by Institute of Chartered Accountants of India under the aegis of IFAC.
Gunjan ma'am, please start.
Hello once again. We are delighted to welcome you all in this webinar being organized by the Continuing Professional Committee, that is the CP Committee of ICAI. It gives me immense pleasure to be a moderator of this session, which is a webinar on valuation, startups, and challenges of competition regime for the industry. In a short while, we'll start this webinar. But before that, I would like to appraise about the CP Committee. So as we all know, the profession of chartered accountancy has always been recognized for the quality of education, training, and strong grip over technical standards. And with globalization and increasing business complexities, it is essential for the chartered accountants to equip themselves with the changes occurring so that they stand out with the expectations of the society. I feel proud when I say that our institute is constantly working and contributing to cater to the needs and requirements of our members and has taken various initiatives for them from time to time in this direction. With this view, the CP Committee of ICAI has always been the foremost to provide opportunities to their members to boost their knowledge base. So in this regard, we have two sessions lined up for today, which will be covered by eminent and talented speakers in an hour each. The topics are challenges of competition regime for industry and valuation startups. However, before this, I would like to introduce you all to a very dynamic personality and Mr. Advocate Manas Kumar Chaudhary, sir. He'll be covering the topic challenges for competition regime for industry. Before I hand over to Sir Chaudhary, I would like to put light to the fact that he is an extremely learned person. He has completed his BSc, MA in History, LLB, and LLM. He has also completed PG Diploma in International Law, Institutions in Diplomacy, PG Diploma in Personnel Management and Industrial Relations. He is an antitrust lawyer. Hello, am I audible? As I was mentioning, Sir Chaudhary has completed his BSc, MA, LLB, and LLM, and has also completed PG Diploma in International Law, Institutions and Diplomacy, PG Diploma in Personnel Management and Industrial Relations. He's an antitrust lawyer for about 22 years from now. And he's a regular panel speaker on the subject of both domestic and international antitrust law events for the over past 18 years. He regularly argues regularly before CCI and the specialized appellate tribunal and occasionally before the higher constitutional courts on competition law matters. I invite Sir Chaudhary to impart some of his widespread knowledge. Thank you.
First, I want to thank you, Indian Institute of Chartered Accountants Association, ICAI, and Mr. Rajkumar Adukia, because he has been a very old friend of mine. I have been associated with ICAI right from the time I worked in the CCI in the year 2003, because this commission and ICAI both are being controlled by the same nodal ministry. And the ministry wanted that the three institutes which directly work under the Ministry of Corporate Affairs, that is ICAI, ICWAI, and ICSI, they should also handhold the Competition Commission, because Section 35 of the Competition Act actually enables a chartered accountant to represent his client's case before the CCI alongside with a lawyer. So this is a unique ability for a chartered accountant to espouse the cause of his client or the represent a client before the CCI. So which we know until now, many chartered accountants do appear before CCI in merger control matters, very rarely for antitrust litigation. But in merger control, what I know from the information we have, that many of the chartered accountants directly file on behalf of their clients. So what I just wanted to share with you is that this is a great opportunity for having a professional interface with a regulator as powerful as the CCI. So this is one area, and I think this goes very well with the objective of what the ICAI is aiming to do in the November International Conference. You should highlight that this is a regulator which actually gives the mandate to a chartered accountant to appear for and on behalf of their client and represent them before the CCI. This is something which I think no other economic legislation has this mandate in the law provided in itself. Because if I say economic legislation, I am starting from say SEBI 1992, IRDA, TRAI, CERC, PNGRB, AERA, and the Real Estate Regulatory Authority. I personally know for sure that at times we do reach out to the chartered accountants to help us while we want to get certain forensic technology experts. And in such circumstances, the chartered accountants come in very, very useful and handy for us to adduce evidence for our clients. So with that little background, I just wanted to share with you that this is an opportunity for all of you to really, though I am sure that you know competition law quite a bit, because this has been in the space for last, I would consider it 20 years, though the Supreme Court judges say you can never say a legislation as young as 22 years. Supreme Court judges do not believe that it is a young legislation. They say it is in the statute book for over 19, 20 years. You cannot call it a young jurisdiction at all. So the jurisprudence which may have evolved in the last 10 years, because the Competition Commission has actually come into being on 20th May 2009. So that is the reason, we call it young jurisdiction, but be that what it may, it's a very, very interesting legislation. It talks about dovetailing business economics with law. And I will just go through my slides, and in between I'll be happy to take questions. So I'm sharing my slides. Let me try. Yeah. So my topic is challenges in enforcing competition law. Why do I say so? Because during the last, say about 2009 until today, 13 years, I have been representing industry in almost all sectors before the CCI, even the investigator, and also the appellate tribunal. What I find is, despite the fact that the CCI has a mandate to make an awareness of this law under Section 49 of the Competition Act to the industry and the stakeholders, awareness amongst the industry, barring those who appear before CCI or who are being investigated before the CCI, the domain knowledge in the industry is still at a very low level. People still ask some basic fundamental questions. Why can I not discuss price with my competitor? Why cannot ask my distributor not to sell the product as directed by me, the price? So these are basic fundamentals of competition law, which is still not known to the industry. Hence, the challenges in enforcing competition law is on the both. I'll try. How do I make it full screen? Just a minute. Slideshow. Just a minute. Yeah, because there is something. Yeah, slideshow. Yeah. Yeah. Is it fine now? Where is that? No, the screen is now full. I don't see anything on the top. Display setting. Where is that? Yeah. Yeah. This is okay. Now the problem is that I'll be losing that button for the next slide. Arrow key is of course not here. Yeah, sure. So is it now full screen and everything is fine? Okay. So the Competition Act, prior to this law being passed by the Parliament, there was a high-powered committee set up by Government of India, which is typically known as of today Raghavan Committee. So this Raghavan Committee actually was given a mandate to understand post-economic liberalization adopted by Government of India in 1991 and in 1995 when India signed the WTO, as to whether or not the MRTP Act should continue or there should be some kind of a new legislation ensuring the confluence and conjunction between the economic liberalization policy, WTO on one hand, and the competition regime on the other. So they actually deliberated upon to see whether the MRTP Act could have been amended. But unfortunately, it could not have been amended because the regime of MRTP Act was very, very different. It actually was something which prohibited the private industry to grow. The basic interest of the MRTP Act was to see that the private industry do not go beyond a percentage of 25 market share, and which is contrary to the economic liberalization policy of 1991, as well as the free trade regime created under WTO was also coming in some way of a conflict with the MRTP Act's concept. So the Raghavan Committee suggested repeal of MRTP Act and writing of a new law, which should be in line with the international best practices, especially available then in the global community. Obviously, when we say global community, we're talking about the United States, which has the competition law in 1890. Then we have the Treaty of Rome in 1957, which actually gave rise to the European Union, and the European Union means the European Competition Agency. And then obviously some other advanced jurisdiction like UK, Australia, all of these were studied by the Raghavan Committee, and ultimately they decided to have a fresh law under the name of Competition Act. And the bill was presented in the Parliament in December of 2002. And on 13 January 2003, the MRTP, Competition Act got the assent of the President, and it became the law of the land. Unfortunately, as soon as the law came into being, the people in the MRTP Commission, as well as the legal fraternity and the professionals in MRTP regime, felt that since the MRTP Act had all along been headed by a judge or a retired judge, how could a new commission, which is going to replace the MRTP Commission, would be headed by an expert? So that actually prompted them to go to the Supreme Court. Obviously, they initially had gone to the Madras High Court in August of 2003. Then in October of 2003, they actually challenged the entire structure of the new Competition Act before the Supreme Court. And that typically is called Brahmdad versus Union of India. And the writ petition number is 490 of 2003. So the whole question actually revolved around one thing, that the Competition Act is a mix of microeconomics and law. It necessarily may not require to be headed by a judge or a retired judge. It can be headed by an expert who has the combination of both law and microeconomics. Ultimately, all these arguments were adduced before the Supreme Court, and finally on 20th January 2005, Supreme Court has actually disposed of the matter with an observation. I would not consider that as binding upon the Union of India, but the observation was very, very clear that the Commission, in terms of the Competition Act, had very clear, distinct role. One is that of an adjudication, the other is that of a regulation, another third role is that of an advisory, and fourth is inquisitorial. Now this four, if I can analyze, adjudicatory means you are actually deciding disputes between two disputing parties, and the Commission would then, based on the evidence adduced by both the parties, will decide as to who is right between the two. So it is adjudication. What is advisory? That is what we are doing, the competition advocacy. CCI has a mandate which the MRTP Act did not have, to make public awareness to the stakeholder as to what this law is all about. So that is advisory. The regulatory is definitely merger control, which is called regulation of combination. Under MRTP Act, it did not really have it. Of course, it did have until 1991, but in 1991, the limited merger control powers of the MRTP Act were also deleted. So naturally, merger control is one of the most economic efficiency enhancing activity of any business economics. So with the merger control not being there in the MRTP Act, that actually made Supreme Court to observe that it has got a regulatory role also. And then comes the last, the inquisitorial. Inquisitorial is the office of the Director General. That means you actually investigate. So with this observation, when Supreme Court disposed of the matter, the government thought that since the consideration of the Supreme Court has been very clear, it is better that we amend the law. And in September of 2007, the law was amended. The structure of the commission is changed. Earlier, it was the CCI and the first appeal would go to the Supreme Court. From there, it changed to an appellate tribunal was created between the CCI and the Supreme Court. However, the jurisdiction of the Supreme Competition Commission and the appellate tribunal were remained exclusive. No other civil court had any jurisdiction to even initiate a proceeding of competition dispute or competition merger regulation. So this actually made the hierarchy very clear. There is CCI at the for understanding the subject at the trial level. Then you have the appellate tribunal. Earlier it was compact. Now in May of 2017, it has been merged into NCLAT. So NCLAT is the first appellate tribunal and then the Supreme Court on points of law. So this structure was created post amendment of the Competition Act in 2007. Until May of 2009, the appointments of the members of the commission as well as of the appellate tribunal were completed. The regulations were drafted and got the vetting of the Ministry of Law and the Parliament. And in May of 2009, the enforcement sections, that is Section 3, relatable to anti-competitive agreement, and Section 4, relatable to abuse of dominance, were notified. And appellate tribunal and the CCI both got notified by the government. In September 2009, the MRTP Act was repealed and the dissolution of the MRTP Commission was completed. And on 1st June 2011, the merger control got notified. So this is the brief background as to how this whole regime transited from MRTP to Commission. And why? Because there was an economic liberalization adopted. India signed the WTO in order not to create an imbalance between the domestic industry and people who would be entering into India with the free trade under the WTO regime should not really damage the domestic industry. So all of these were thought about, and hence a Competition Act with the mandate of extraterritorial jurisdiction was created. I'll get into that little later. Let us first understand the scheme of the Act. It's a civil legislation. There are many jurisdictions where Competition Act is criminal in sanction, but in India it is thought to be kept a civil law. That means preponderance of probability is the key for the CCI and also for the appellate tribunal to see as to who between the two parties are able to give the better evidence, ensuring that the authority to close the matter based on the stronger evidence. Section 3 and 4, these are the two prohibitory decree of the Competition Act. Why do I say prohibitory decree? The enterprises are prohibited to enter into a conduct, business conduct, which prohibits or distorts competition in the market. So when I say prohibits or distort competition in the market, what do I mean? I mean that in the case of a cartel, the parties come together and secretly make some collusion. And then this collusive conduct of the competitors, they distort the market by fixing the price, the manner in which they believe it would be more profitable for their business. They might even participate in a public tender, public procurement by rigging the bids, or it can even enter into some kind of an exclusive arrangement with the downstream business players, thereby distorting the competitors to enter that same market. Or they can even adopt some unfair and discriminatory condition, create some kind of a market entry barrier. They deny the market access. For example, I can give you an example, say what is a dominant player in unilateral conduct can be. Say, for example, I'm just giving an example. Say Coal India Limited is a public sector undertaking. So before I get into that, I would also like to share another distinctive feature between the MRTP Act and the CCI. The MRTP Act did not have any ability to investigate public sector undertaking. So that has been done away with. The Competition Act is sector agnostic as well as it is competitive neutral. What do I mean by that? That means public sector undertaking and the private are both can be investigated and handed out with sanctions. So coming back to that, Coal India Limited is not only dominant, it's a monopolist, because in India, there is no other authority who actually produces coal. So Coal India Limited, while adopting the fuel supply agreement in the year 2009-10, they created certain clauses in their fuel supply agreement to the buyer of coal in such a manner that the buyers were agreed. They felt that the Coal India Limited, by exercising their power of monopoly, is creating some unfair and discriminatory conditions. In the process, there is a market distortion. Interestingly, most of the buyers were also state utilities, like the State Electricity Board and other state utilities. So they were trying to espouse the cause that even between NTPC and State Electricity Board, Coal India Limited was giving better coal to NTPC, the coal which has a better gross calorific values. On the contrary to the State Electricity Board, the coal which was given by them under that agreement were most of the time having almost half of the gross calorific value. So this point was agitated with the agreement parties adduced before the CCI, and CCI found that the Coal India Limited was actually unilaterally deciding as to what kind of coal to be given to X buyer versus Y buyer. And during the continuance of this investigation, the CCI directed the Coal India Limited to modify some of their agreements, and they did carry out those modifications in compliance with the CCI's directives. However, the penalty which was imposed upon Coal India Limited initially was about 1773 crores. And how do I get that amount? The law says based on the turnover of the defaulting enterprise, the average 3 years turnover of the defaulting enterprise up to 10%, the CCI can impose a penalty. CCI imposed a penalty only up to 3%, and that 3% of Coal India's turnover in the 3 years was 1773 crores. So you can imagine how big it is. However, in appeal, when they had gone, they said that we have carried out all those changes as directed by the CCI, and appellate tribunal did make some kind of a leniency, since public sector undertaking end of the day is also some kind of a taxpayer's liability. The penalty was reduced to 1/3, and it ultimately was handed out with a 591 crore penalty. What do I actually try to adduce from this? That an unilateral conduct of a monopolist or a dominant player can be investigated in this manner, where the agreement may be available. On the contrary, in case of a bid rigging or a cartel, the agreements may not be available. And that is the reason, the definition of agreement under the Competition Act has been made quite different from the Indian Contracts Act. Indian Contracts Act says any agreement enforceable in law is a contract. On the contrary, here in Competition Act, in order to catch hold of cartel and bid rigging, the Parliament decided to define the definition of agreement in a very, very broad manner. It says any understanding, any undertaking, any agreement which even cannot be enforceable in law is an agreement. Now, this is something which is very interesting. Agreements which are not enforceable in law, if it actually throws up some kind of an appreciable adverse effect in the market and is collusive in nature, then even that kind of understanding between competitors would be considered to be an agreement under the Competition Act. I'll give you an example. Two competitors entering into a golf course on a Sunday. Both of them signed the members register for playing golf on a Sunday. On the Monday, following working day, they were actually competitors in a particular business. Following day, the price of the product of both of them increased by 5%. The signature made by them in the golf course on Sunday was considered an agreement in terms of Competition Act. So this is the length of up to which this agreement for bursting cartels and bid rigging can go in the Competition Act, with an only objective of seeing the market is not distorted. So the judicial process had gone up to Supreme Court, where the Supreme Court said that it should be a necessary party. It should not be anyone coming in the fray. You have to identify who, according to you, is a necessary party, who is a proper party. And that is the reason in many cases, people challenge that why is CCI before the appellate tribunal? Why is CCI before the Supreme Court? It is an adjudicator or a regulator. Once it has passed an order, it should be functus officio. It should not be really bothered about who actually wins the matter. But the Parliament thought that if the regulator is not there in the appeal process, then perhaps these technicalities of how did it reach to the conclusion based on the economic analysis may remain to be still probed by the appellate tribunal. In order to minimize the time, they have decided to make CCI a proper party. And in the case of a suo motu investigation, which the CCI has power, it shall be the necessary party. So these are some of the issues which, over the years have been evolved. The individual liability is a very high risk in Competition Act because, end of the day, an enterprise is of a brick and mortar. It really cannot be liable to commit a competition law breach. So who does this breach? So naturally, the law says the commission can go and find out by raising the corporate bail to find out who the individual actually was directly responsible for or contributed to the antitrust breach. So the individual liability risks are very high, and the CCI has regularly been investigating individuals and handing out penalties to them. Now, coming back to the ex ante regulatory mandate of the CCI, that is the combination. Here, there are thresholds prescribed. Some exemptions are provided in the threshold, and parties, if they meet the threshold, they do not have any option but to go before the CCI with a filing fee and wait until the CCI approves the deal. So it is a compulsory and a suspensory regime. You do not have a right to close the deal. If you do so, immediately the CCI can initiate the proceedings of gun jumping against the parties who, without the approval of the CCI, has closed the deal. There are many gun jumping proceedings being filed against parties who have closed the deal, and the CCI is regularly monitoring through the public domain information as to the combinations which are being closed but has not come to the CCI, and they are investigating whether there is a gun jumping or not. So something which, over the years, people must be aware that they cannot really close the deal. They cannot enter into collusive agreement. They cannot exercise unilateral conduct by denying market access. Chapter 6, 4, 5, and 6 are little procedural. I hope you guys are aware of how this procedural adjudication takes place. I'll be happy to take questions if there are any, because otherwise I'll not be able to complete within the time allotted. The power of investigation under Chapter 5 is exclusively given to the DG. DG, however, is a civil court under Competition Act in terms of Section 36 of Clause 2, but CCI is also a civil court. However, the powers of the CCI and the DG are specifically defined under Section 36(2). They cannot be a civil court like what we conceive as a civil court, or they do not have the power of the appellate tribunal, which has got even wider power of a civil court. However, they have got the basic minimum powers of a civil court. Otherwise, the Evidence Act and the other acts would not be able to be applied. So the power of investigation, though, is very specific but limited. However, the DG has enormous powers to complete the investigation the way it wants. It has got powers to make an unannounced search and seizure, which typically is called dawn raid. They can just enter into the premises of any company allegedly involved in any kind of antitrust issue, and they can catch hold of the computers, the systems, and also the mobile handsets of the senior functionaries, and get these hard disks investigated through the forensic technology. And if they get appropriate evidence, the matter is over and out for the company. They just cannot defend because it is taken in such a manner that you do not have a right to even go and say that there is error in procedure. Error in procedure can be adjudicated, but at the same time, in a forensic technology, it is very difficult to defend. So these powers were not there in the MRTP Act. These are very draconian power, and the DG has this power. However, DG requires to take a warrant from the Chief Metropolitan Magistrate, New Delhi, before causing the dawn raid. That's the only filter. It just cannot have the DG to do it on his own. He has to go and satisfy the Chief Metropolitan Magistrate, who is not within the competition regime, to go and satisfy that the dawn raid is required. However, whenever the dawn raid happens, the Chief Metropolitan Magistrate, more often than not, had agreed. So the dawn raids are very substantially happening in India. Even during the COVID time, there are about 5-6 dawn raids happen during the COVID time. So dawn raids are right there, and everyone is scared of this dawn raid. Chapter 6 talks about non-compliance and the penalties, and they also have the system of whistleblower, which is called lesser penalty regulation. These are all available in Chapter 6. Lesser penalty regulation or whistleblower is typically available to a party who is in cartel and wishing to disclose the cartel of the others. And obviously, this is something which is very, very a formidable power of the Competition Act, and many competitors of cartel had gone before CCI and tried to blow the whistle. Going over to competition advocacy, I've spoken about that. And then Chapter 8 of the Competition Act talks about the entire money of whatever is being recovered, either by way of a filing fee, that goes to the competition fund, but the penalties go to the Consolidated Fund of India. That means the government actually gets the money for enterprises in breach of Competition Act. The purpose is to make that money plow back into the market to make a consumer surplus and the consumer welfare. It is yet to happen because most of the penalties which has been imposed by the CCI are still in the appellate tribunal. Unless those are disposed of, obviously penalties cannot be recovered. Provision of appeals are available in Chapter 8A, and Chapter 9 talks about the powers of government, which of course in public interest. So any questions, I'll be happy to answer. I have not been able to open the chat box. If at all anything comes up, you can just really tell me. So the structure of the commission is the CCI is constituted under Section 7, 8, and 17 of the Act. It is independent insofar as the structure of the Competition Act is concerned. However, there is a bit of a fetter to independence, is that it is relying upon the funds from the government. However, the funds are being appropriated by Parliament, and thereafter the funds are being defrayed to the CCI through the competition fund. The DG is considered to be an independent at arm's length from the CCI because it has been set up under Section 16, whereas the commission is set up under Section 7, 8, and 17. So DG is a specialized investigative wing whose mandate is to assist the CCI in its investigation. Section 41 talks about the powers of the DG. The appellate tribunal is created after the amendment, which is a special chapter, and the appellate tribunal is only looking into the orders which are available under Section 53 capital A to only look into those appeals. All orders of the CCI are not appealable before the appellate tribunal. Under Section 53U, they have got power to issue contempt, which the CCI and the DG do not have this power of contempt. And under Section 53T, every order of the appellate tribunal can be appealed before the Supreme Court. Most of the time, Supreme Court looks into the final appeal only on points of law. So this is the structure. Then we come to the procedural regulation. Every facts whichever you adduce before CCI, either through the process of information filing, it must be supported by an affidavit. Then you cannot give any additional evidence unless it has been allowed by the CCI. The authorizing representatives to appear, here I really talk about the chartered accountants under Section 35 can also make appearance for their parties before CCI alongside with lawyers, cost works accountants, and the company secretaries. Entire hearing under Regulation 47 of the competition regulation will be in camera. The reasons are very simple, because parties, when they actually go and open up their arguments before the CCI, they mostly talk about their business confidentiality. Unlike civil court, the confidentiality which is being adduced in oral arguments before the CCI are not available in public domain. Hence, and the entire hearing before the CCI happens in camera to protect the commercial interest of the parties. The imposition of penalty, of course, the CCI has a mandate to give an opportunity of being heard. However, the parties are aware the moment the investigation is over in the final hearing, the CCI typically asks the annual ITR returns of the individuals and the balance sheets of the company, which clearly makes it that there is a possibility of computation of penalty against the company as well as the individuals. And that is what the parties can even have their own arguments against that. So it's actually based upon principle of natural justice. No other legislation in India, economic legislation in India, has a provision like 36 subclause 1, which is in the Competition Act, which says the CCI shall be guided by the principle of natural justice and the provisions of civil procedure code will not apply. That clearly gives the mandate that you have to give an opportunity of being heard to the party whom you want to impose penalty, or the CCI should not become judge in its own cause. It has to be impartial and neutral. Of course, there are some procedural issues. You can cause inspection of record. You can also pay the charges for inspection of records so as to ensure that you get the opportunity of defend yourself properly. So the appeals, are statutory appeals. The high courts do not have any jurisdiction to listen to the CCI's order in appeal. Of course, the high courts continue to enjoy the writ jurisdiction, which is independent of Competition Act. Section 53 capital A and B actually defines which section orders emanating from which section of the Competition Act can be appealed. All orders cannot be appealed. Section 53O and 36(3) is very interesting. 36(3) had the provisions of IPC 191, 193 to actually force the deponents to come clean before the DG. This power has been taken away in 2007 amendment and has been given to the appellate tribunal, which clearly makes the appellate tribunal as the civil court in full sense. Whereas the DG and the CCI are limited civil court without the powers of a civil court as enshrined under IPC 191, 193 and 228. These powers are given to the appellate tribunal. 53T I have spoken about, that it is the appeal to the Supreme Court. The most interesting is the 53N. 53N talks about the compensation regime, and this procedure can only be filed before the appellate tribunal. Hence, the appellate tribunal is the court of original jurisdiction for getting a compensation application filed only when a final order of the Supreme Court has been found confirming the breach of the Competition Act by the respondents. So any plaintiff who is actually aggrieved by the final order of the Competition Commission confirmed by appellate tribunal and Supreme Court can come up before the NCLAT, file a fresh application, not appeal, of legitimate compensation for the breach of the Competition Act. Thereby, it can claim compensation, and also there is a class action possibility. People who are not even the parties before the CCI, but were affected by this order of the CCI, they can join the compensation application and proceed with a class action application along with the original agreed party. So these powers are yet to really emerge because it's still not matured enough, but globally, the compensation applications and class actions are very rampant, and entire regime is now thinking about that whether or not to really entertain leniency, because once you have become a whistleblower, you are having no defense in the case of a compensation because you have admitted the guilt yourself. You have got the immunity from the commission, but your challenge and risk before the compensation application case becomes the weakest because you can't defend that I was not in a cartel because you admitted the guilt. So that is the reason in global latest jurisprudence is lesser leniency applications are coming before commission. Compensation applications are going up. And this is something which the international community is currently grappling with, and perhaps that will happen in India also in some times to come. So these are some of the issues which I thought I should share with you. What are the challenges? The statutory, this is the core area of actually my today's topic. The statutory regulations issued at regular intervals. Sometimes those statutory regulations which are being issued from time to time are good for the industry, but sometimes it is not so good. And that is where the industry will have to really assess whether these regulations being issued by the CCI, because they are binding upon the enterprises, they should really be seeing how far the risks have been mitigated or has been enhanced because of these new regulations. The tenures of the chairperson and members are too short, which results into institutional memory loss. So if suppose that members and the chairperson are mandated to only work for 5 years, unfortunately, most of the people are retired from their government jobs. When they come, they are already over 60 years plus. And the mandate under the Competition Act is either you are 5 years as a chairperson or a member, or 65 years, whichever is earlier. So in such circumstances, the chairperson and members who join after 60, they do not have a full 5 years tenure. And with their departure, the new persons come with the new ideas, and the institution continues to lose its memory, which is again a challenge to the industry, because one chairperson might say that I prefer to investigate more on economics. The other chairperson might like to say, no, I want to investigate more on law. So this lopsided kind of a conception and a perception of the members and the chairperson do not give a predictability to the enterprise. And that is where I personally feel that the tenure of the chairperson and members being too short actually causes quite a substantial unpredictableness to the industry. The office of the DG is even more temporary. Their tenure is mostly on deputation for 3 years. And some of them are from the Indian Revenue Services, some of them are from the Indian Police Services, and currently even some commissioned army officers are also part of the investigation. So here also we believe that the domain knowledge with regard to an economic legislation like Competition Act is sometimes being compromised and the industry suffers. And that is the area where, the litigation cost goes up. The parties rush to the High Court, challenging the due process and the principle of natural justice issues more often than not, since the High Court's original constitutional writ jurisdiction is available against the CCI and the DG. So that is another area which is a challenge to the industry. A comprehensive amendment of the merger control have already been made and continuing. Say, for example, in August of 2019, the CCI has issued a regulation that there can be a green channel filing. What is green channel filing? If you can show that the acquiring party and the target can show that there are no overlaps either in the horizontal market, that is the market where the competitors are interface with each other, or vertical markets, that is between the supplier and the distributor, or complementary market. Complementary market, loose example can be a printer and a cartridge and a computer instrument. So if you can show that there are no overlaps in either of these three markets, then a green channel filing can be made, but that filing will have to be made in the statutory form with the statutory filing fee. The only advantage is that you do not have a waiting period. The moment you have filed it before the CCI, Combination Division, and with the stamp of acknowledgement, it is deemed to have been approved. So in the last 3 years, nearly 3 years, amongst the total number of filings made before the CCI, the normal filings, 25% plus are the green channel, which clearly shows there is a very interesting development that the parties do not have to wait for competition assessment to be made by the Combination Division post filing of their form and filing of their filing fee and waiting. So that waiting period has been minimized to 0. That's a great amendment, but at the same time, I will share with you that non-compete clause, which was earlier available for an assessment by the Combination Division in a merger control, has been taken away. Why? The CCI says that the non-compete is otherwise available under the several other civil legislation, and which can be argued and disputed by any private parties entering into an agreement in terms of the relevant provisions of the Indian Contracts Act. If we now impose a non-compete clause also as part of competition assessment, it is actually delaying a merger control. Hence, the Competition Commission had decided that non-compete clause assessment in merger control shall not be required any longer. However, a non-compete clause can also be investigated under cartels as well as under abuse of dominance. So in merger control, it has been waived, but not in the antitrust. Amendment, comprehensive amendments is in the anvil. The bill is available in the public domain. March of 2020, the competition amendment bill is there. Salient features of the competition amendment bill is that the commission is now trying to espouse the cause of commitment and settlement. What do I mean by this? Commitment and settlement means that if you are investigated for any antitrust issue relating to vertical agreements and abuse of dominance, you can go to the CCI depending on the kind of prima facie order CCI made and you believe that the investigation ultimately will go against you, you go before CCI, admit that I want to make a commitment, please withdraw the matter. And once the commitment has been agreed to by the CCI, the investigation stops. The parties also do not really want to go in appeal. And in the process, the matter gets settled between the parties based on the commitment. Whereas in the case of settlements, after the DG completes the investigation report and the parties find that, yes, I am likely to be handed out with a penalty, they come up before CCI and tell them that I want to settle this matter, kindly allow me to settle this matter, and please don't impose any penalty. I am agreeable to making the settlement as the commission may like to give directions to. So these are international best practices with the amendment of the Competition Act, which is likely to be introduced in India of the Parliament after approves this bill. The other salient features of this amendment, significant salient features of this amendment would be, once a party has been handed out with a penalty, the appellate tribunal may direct the parties to deposit 25% of the penalty amount before the appeal can be instituted and can be heard on merit. So sometimes it can be quite draconian because the CCI can impose a penalty to the tune of, say, about 1,000 crore upon a single individual company, which means 250 crore will have to be deposited. Thereby, they would be then allowed to really go ahead with the appeal on merit. And once you deposit a substantial amount in government exchequer, even if you win the matter, it would be quite difficult to get it back so easily. And after so many years, when the appeal gets disposed of, your money gets stuck in the government exchequer. So this is something which the industry is really worried. How would you really work out that? That is yet to be seen. Intellectual property generally confers upon any party a legal monopoly. So the commission suggested to the government that if this legal monopoly of IPR, say for example, copyright, trademarks, a patent, if this can also form part of an investigation under abuse of dominance. If suppose a party having an intellectual property, which is of course registered under respective intellectual property laws, say for example, patent can remain valid in favor of the patentee for 20 years, copyright can remain in favor of the copywriter for 50 years. So if those are being implemented in letter and spirit in terms of the IPR, then it's fine. Sometimes what it has been seen that in exercise of this legal monopoly, the IPR holder tends to abuse the market power. And in the process, there is an overlap between a competition agency and a patent director general. So in global antitrust regime, it has been found that abuse of dominance and IPR are investigated from time to time, and CCI wanted this enabling provision to be included in the competition amendment bill. The third very interesting change which is likely to happen is a buyer's cartel. So whenever the buyers are together and they're forcing the sellers to supply it in this manner according to the buyer's diktat, those things are still not very prevalent in the Competition Act. So the Competition Law Review Committee, which actually had suggested these changes, has been adopted in the competition bill, and buyer's cartel is also likely to be included in the amendment of the Competition Act. We would wait and see. We have been told that in monsoon session, that is, which is starting next week, is likely to come this week, this session. If it gets through without any select committee being overseeing the bill, perhaps the Competition Act would stand amended very soon. We have to wait and see. Penalties imposed until now by CCI is to the tune of about 15,000 crore. That's mind-boggling number. Unfortunately, the recovery has been around 89 crores because all the parties who have been handed out with penalties have gone to the appellate tribunal. Some of them have gone to the Supreme Court, and in the process, the whole recovery of the penalty is being delayed, and that is what I think is another area to be considered. The last one is that it is a civil law, and most of the time the investigators, then they're coming from various backgrounds. So for example, tax, police, they try to make the entire competition investigation not so civil. They try to apply their own domain knowledge and at times make grave error which lead parties to go to the writ court. So this is something which is also a challenge. The case laws which I thought to share with you is this. initial phases. I'll be ending up in just about 4 or 5 minutes. In the initial phase, that is 2009 to 2012, when the CCI was about to really launch its activities under Section 3 and 4, because Section 5 came only in June of 2011. So until 2012, not much happened in merger control. So in the first 3 years, there are certain judgments which over the years have been compromised, because they were initial judgments where the CCI was very lenient, despite the fact that the cartels were proved, they did not impose penalty, they just had handed out with cease and desist order. Similarly, the abuse of dominant cases were running out of some kind of an economic analysis, and they were also closed, and combinations just had taken off, and not much happened in the initial 3 years. The most interesting phase started from the middle phase, that is 2012 to 2018. 43A typically talks about gun jumping. Plethora of gun jumping proceedings have been initiated and concluded. Public sector undertakings were handed out with huge penalties. Example of Coal India Limited. Then also the public sector insurance companies, they were into cartels. They were also handed out with a penalty which has been confirmed in appeal. Then there are two phases in combination. One is phase one, which is simple, that you file a form 1 and you make the assessment with the CCI and you get the approval. But in phase 2, it is a complex merger where the CCI believes that unless I really have a public interface, I would not like to really close this combination. So in phase 2, the third party interventions are allowed, and in the process, the entire waiting period gets extended. So in the middle phase, there were phase 2 filings happened. The most glaring example, the first case was Sun Ranbaxy. When Sun was acquiring Ranbaxy in the pharmaceutical sector, the CCI found that out of 65 molecules being considered to be acquired by Sun, there were 6 molecules which would be post-combination having a market share of 65% plus. And CCI directed Sun to divest these 6 pharmaceutical ingredients, active pharmaceutical ingredients. And with the divestiture, the combination was allowed. And that was the beginning of phase 2. You may have read the PVR-DT, where also Inox became the intervener. Then Linde, Praxair, that also was a phase 2. Then L&T Schneider, that is again a phase 2. So phase 2, whenever happened, these were complex transactions. Some of them even could have been blocked by CCI. What does CCI do in combination? Either it approves, or it directs a modification, or it rejects the entire transaction. Until now, 975 merger control applications have been entertained by CCI, and only about 20 cases had gone into phase 2. And in phase 2, CCI had actually handed out with modification. So the record of CCI in merger control is to the tune of about 98% approval without any modifications. So that's a great regime. Leniency regime, I talked about the whistleblower regime. It's very thick and fast. Several of the cross-border leniency applications have been filed. We have represented quite a number of companies. And the latest one is the beer cartel, where you must have seen that Anheuser-Busch, United Breweries and Carlsberg, they all filed leniency application and handed out with huge penalty to the applicant number 2 and 3. And the first applicant got 100% immunity because it actually blew the whistle of the cartel amongst the 3 beer companies. NCLAT, which is the appellate tribunal, on May of 26, 2017, it has been merged with the appellate compact was merged with the NCLAT, and that also had considerably slowed down the jurisprudence evolution, because NCLAT is totally bogged down with IBC and other company law matters, and obviously the Competition Act also gets some kind of a lower priority because they are flooded with other matters. So the jurisprudence evolution has slowed down substantially. 2019 onwards until now, the dawn rates have increased a lot. In COVID time, when even the immunization or vaccination did not start in India, in December 2020, the cement industry was being raided. And that was quite surprising. People were called from their residences to appear before the DG in their offices. So even the people were not sure whether without a vaccination, do I really go and interact with this authority? But however, that happened. Minimum resale price maintenance is one of the most talked about judgment during this period. That is, Maruti Suzuki was handed out with 200 crore penalty when Maruti was found to have directed all its dealers to sell the Maruti products at the price fixed by Maruti. And if they do not do so, they were imposing penalty upon the dealers, which were all evidenced and proved. And that is where the minimum resale price maintenance had become talked about in this period. Last one is that Amazon and Future deal, which was initially approved without any condition by the CCI. Subsequently, some interface happened with a complainant who is a Brick and Mortar Traders Association, and CCI initiated that process and found some evidence whereby they suspended their own approval order. 2 years later, the approval was granted. Matter went to the appellate tribunal, and in appellate tribunal also, Amazon could not convince the appellate tribunal, and they confirmed the CCI's judgment. There are quite a number of Supreme Court ratios happened in between. One is very interesting, that relevant turnover. If the parties are multi-product company, then only the product in which the investigation has happened. Earlier, CCI was imposing penalty on the global turnover of the company. The Supreme Court in Excel Crop said, no, you only can impose penalty on the product which is being investigated. So I stop here. I'll be happy to take questions if you have any. I stop sharing the screen. Yeah. Let me see the chat box if there are any questions.
Amrit, just see if there are any questions. Kunjan, please assist us. Manasji, I think there are participants have understood everything.
Okay, good, very good.
Gunjan, we can proceed further.
So can I...
just wait for a minute, sir, Manasji.
Okay.
Okay, Amrit, thank you. Friends, we are, Gunjan, if you want to take a minute, take a minute. Otherwise, I'll proceed with what I want to say.
Hello.
Yes, Gunjan. Gunjan, let me. Yes, Gunjan.
Yes, sir. What a session. Thank you, Chaudhary, sir. We are glad to have attended this webinar as we did learn from you a lot today. So going ahead, I'd like, someone once wisely said, education is about creating leaders for tomorrow. So I'm elevated to introduce you an erudite personality present with us today, CA Dr. Rajkumar S. Adukia, sir, the chairman of CPE committee. I'm in awe with CA Adukia, sir's educational qualification. He's a BCom honors, FCA, FCS, FCMA, LLB, MBA, MBF, MCom, Diploma in IFRS UK, DLL and LW, DIPR, Diploma in Criminology, PhD, IP, IBBI, and UNO DC Advanced Anti-Corruption. He's serving the ICAI in various capacities since 1998. Presently, he is serving the ICAI as the Central Council member and also the chairman of CPE committee, CPEC, CCL, and EA and CDS Directorate ICAI. Sir has left no stone unturned during his career span, expanding to more than 37 years. He is a pioneer of many areas of practice which were never even thought of by professionals. He served as the president of GST Research Foundation, and he is the chairman of Association of Indian Investors and vice president of All India Insolvency Professionals. He has mentored over 1,000 professionals for passing the insolvency exam and valuation exam. He has authored more than 300 books on a wide variety of topics, ranging from those dealing with trade, finance, taxation, real estate, the insolvency and bankruptcy code, IPR, banking laws, emerging technologies like AI and blockchain, to topics relating to personal and professional growth. He's the winner of National Book Honor Awards 2018. Sir is very passionate about learning new things and believes self-improvement is a permanent process. He is always keen in solving problems and has always given solutions to everyone. I very respectfully ask CA Dr. Adukya to please present a welcome address to the dignitaries and attendees of this webinar and enlighten us.
Thank you, Gunjan. First, I would like to thank Manas Chaudhary sir. He is an encyclopedia on competition law, a law which came to India maybe after 100 years when it came to the world first time in Canada. And we took 7 years to implement. You know, the act is of 2002. But Section 3 and Section 4 came in 2009, 20th May 2009, and combination provisions came afterwards. So, sir, you in a very lucid manner, and chartered accountants are the best persons to practice in this law. This law cases are not like income tax and GST, but one case, you know, if you see the penalty amount which is levied, will give one person maybe 1 year's income or maybe 6 months income. So Manas sir, thank you for sparing your time on Saturday evening. And friends, this webinar which we do every Saturday under CTEC and every Friday under Economic and Commercial Law is a platform like Mr. Vijay Kumar Puri. Manas sir, Gunjan is from Guwahati, Vijay is from Mumbai, and yourself from Delhi. So 24th March 2020, we should thank COVID lockdown day, which really taught us technology. Technology was there earlier. But then we started thinking, if we have to remain in our home, what to do? And we found that we can connect the whole world. So I request all members to become a thought leader, to become a speaker, to become a writer, to use social media, which is used by 70% of world population. So we can share the knowledge, and by sharing the knowledge, we can get the work, we can expand our services, we can reach out to who needs our services. And the committee will mentor. Myself will mentor those who are interested. They may write to us. And like Vijay Kumar Puri is one of such member. And every Thursday we have started doing a mentorship program from 4:30 p.m. to 6 p.m. How one can do a research, one can start sharing the knowledge on social media, Facebook, LinkedIn, Insta, Twitter, make a YouTube channel, make a blog, make a website, make posting on online platforms. So I invite each one of you and communicate to your other colleagues also. And I thank Vijay for taking up a very interesting topic on valuation, which is a judgment of a valuer. And it is different than the cost, price, whatever we have learned. Over to you, Gunjan.
Thank you, Adukya sir. You never fail to motivate us. Now, moving on. Who says you can't achieve something big at a young age? Our next speaker, CA Vijay Kumar Puri, is a CA, CS, and a graduate from NM College. He also holds a degree in law from Government Law College, Mumbai. He is a registered valuer in the Securities and Financial Assets class. He is a member of various professional forums and actively contributes by way of articles and technical research papers. He is a published author on subjects of international taxation and valuation. His articles have been published in various prominent professional journals and magazines, including the ICAI's journal. He's an avid reader and has always been passionate about speaking on various forums. And I'm sure that with his knowledge and passion, he will be able to understand the topic of valuation startups without effort. I call upon CA Puri sir to please address the webinar.
So that was a really generous introduction, if I would say, and really thank you for that. And also to Dr. Dukia sir, who's always been a guiding light. And whenever you speak with sir, you are surrounded by positivity. So that thank you so much for mentoring me. And as we have gathered here on this Saturday evening to discuss a very interesting topic on valuation of startups. Now, what is valuation of startups? It's one of the most hottest topics. There is something new in the field every day. So there's a saying that says that if there are 10 investors in a field sitting in a room, there will be 11 valuations which will be available to you. And that explains how dynamic the field is. And it's a very exciting field at the moment. In the recent past, there will not be one financial newspaper where there will not be a news of startups. So this is how amazing the field is. So I'll be sharing my screen at the moment. Just a second. So CA Gunjanji, can you confirm if it is visible?
Yes, it is.
Okay, thank you so much. So when you talk about valuing the 21st century startup, what is valuation in its own? In very simple terms, valuation is nothing but estimating the worth of something. So why do you value something? There are hundreds of reasons, but there's one keyword: to make a decision. It's decision making drives valuation. Now there may be a decision to invest, there may be a decision to exit, there may be a decision to further finance. So there are various decisions which can drive valuation. And how do we actually value a startup is something which we'll be covering in the next 40 to 45 minutes. And moving on, before we actually discuss about valuation of startups, let us first value the Mona Lisa. Now, I submit that I am not someone who can appreciate art in the right way. So for me, I would say that this is a painting. There are hundreds of artworks, very good paintings like this. And so for me, this will not have any special value. But there would be a art critic, and rightfully so, who would say that there is a lot of profound meaning within this painting. Whether she is smiling or is she sad, no one can answer that. So it has a lot of value for that person. So the point I'm saying is that just like beauty, the value also lies in the eyes of the beholder. And now this was about paintings. Now let's talk about startups, the topic of today. Now, if you are aware that last year there was a very celebrated IPO of Paytm. And in that, prior to the IPO, around 6 months or 8 months before the IPO, the startup was valued at $16 billion. During the IPO, they had tried to value the Paytm at $20 billion. But today it is somewhere in the range of $6 to $7 billion. And this is not because someone made any irrational decisions. The value was different for each person who was valuing the company. And that explains that value is different for the person who is being valued. In our valuation reports, there is a mandatory paragraph to be added as to who is the user of the valuation report, because that comprehensively affects how the valuation report would be used and the context, and provides a good context to the valuation. Now, moving ahead, let's first look at what the startup world is at the moment. Before we can dive into the valuation, let's look at what the startup world is. Now, here are two big terms I'm going to be using throughout the presentation. One is disruptors and the other is future. Now, startup by their at their core, they are disruptors. They want to disrupt something. They want to disrupt established practices, find better ways of doing something, and all this to build a better future. So at their core, startups are nothing but disruptors, and the entire focus of startups is on the future. They are not concerned with how much profits they are making today. The biggest concern for them is how much value they can add today to the consumer. So how do they do that? Is by having new technologies, new processes, and new incentives. Startups are chasing valuations. We all know how there's a new unicorn every week, I would say. So this is the age of unicorns. This is not the age of high profit margins or good quality of assets. It is the age of $1 billion valuation. So Simon Sinek, who's a very famous author, he says that whenever you do something, you should always start with why. So why should we value a startup is the primary question that we should answer right now. Firstly, valuation, as I said, it is different for everyone. A founder will value a company differently than an investor. An investor will value a company differently than the regulator. So the value differs for everyone. And that is why a valuation has to be done to know what the value is for a specific person or a group of persons. Now, valuation itself becomes a starting point of negotiations always, because whenever you do a valuation, you have a base to start. Now, most startups are private limited companies, so their accounting is done as per the Indian GAAP, which is the accounting standards, and it is done mostly on a historical basis. So when you read the balance sheet of a startup, you will not be able to understand the true value which lies in the startup. In the balance sheet, there would be losses and probably a lot of liabilities, but that would not reflect the true value of a startup. Now, here's a very interesting statistic. 90% of the startups fail within the first 3 years. Now, this is an unfortunate statistic, but it is the truth. And somewhere in our valuation, this entire statistic needs to be considered. As we go ahead, we will look at how this statistic can be considered in a few valuation methods. So again, the approach has to be different because the value is different for everything. It lies in the eyes of the beholder. And in this way, we should be valuing startups based on who the end user is. So first, let's look at the common valuation approaches, which are commonly used across all businesses. And then we can see how they are applicable or how they may fall short for coming to startups. First is the income approach. Now, this is a very common approach. Whenever you talk valuation, you talk the discounted cash flow or DCF method. Now, a lot of material would be available on this approach across all public platforms like LinkedIn. You would see a lot of people doing valuations using this approach. So in very simple terms, what the estimated cash flows of an asset are estimated and they are discounted to the present value. This brings forth the value of the asset. Now, just to give an example, so say this is a pen and I want to value this pen. Now, hypothetically, I'll say a year from now, this pen will earn me, say, 110 rupees. And today, I want a return of 10%. So I would discount the future cash flow, which is 110, at the rate of 10% to today. So the value of this pen today for me would be 100 rupees. So this is how valuation is computed in the income approach. Forgive me, I've made it, I've tried to simplify it to make it understandable. And now we should discuss why this approach will not work for startups. I'm not saying it does not work, but in its traditional form, it may not squarely apply to startups. Firstly, generating positive cash flows is not the primary goal of startups. Now, as we all know, last year even there was one more famous IPO, in fact, which was the first IPO, Zomato. Now, at the time of the IPO, they had come out with the red herring prospectus. The prospectus had detailed the amounts and the financials of the company. So while they were profitable on a per order basis, they were clearly not profitable on a net basis. So the justification also was that they are spending a lot on marketing and administration costs and expansion and acquisitions. So generating positive cash flow was never their primary goal. So this is this income approach is based out of positive cash flows. The real value comes from the cash flows. So if generating positive cash flows is not the primary goal, for startups, this may not be the right approach. Then there is again, now talking about Paytm's business model. They had clearly mentioned in their prospectus that they do not expect to earn any profits in the foreseeable future, and investors should not expect any profits. So since there are no profits, there won't be any positive cash flow as well. So this also means that the income approach in its simple form may not be directly applicable to the new age startups. Again, this is a statistic my team pulled out. There are more than 80% of the unicorns which are there today make losses. So they all have $1 billion valuations. As a unicorn, they all have $1 billion valuations, but more than 80% of them are loss making. There are very few like Zerodha and Zoho, which actually make tangible profits. So the income approach may not be applicable to at least these 80%. It is again, it is difficult to find the right discounting rates. Now, in the pen example that I gave you, the discounting rate used was 10%. Now, that 10% was an arbitrary number I came up with. But in practicality, how is discounting rate calculated? That is the most commonly used is the weighted average cost of capital. Now, to calculate weighted average cost of capital, we have to take a term which is called beta. Now, beta is nothing but the risk of the business as compared to the risk of the market. And how is beta calculated? It is calculated by doing a regression analysis of the returns of the stock as compared to the returns of the market. Now, during this regression analysis, if the returns of the stock need to be seen for startups, there is no tangible data, or whatever data it is unreliable. So if something like a beta cannot be calculated, it is very difficult to come up with the right discounting rate, and therefore it is difficult to use this approach squarely for startups. Again, terminal value. Now, how DCF works is that the cash flows are forecasted for the future, say 3 or 5 years. Let's take 5 years. So from year 1 to year 5, the cash flows are forecasted and discounted to present value. And there is a very big component called terminal value, which is basically cash flows from year 6 till infinity. Now, these cash flows are also discounted to present value. There are hundreds of ways of calculating the terminal value. What it essentially means is that after a period of time, the earnings of a startup will stabilize. The growth of the startup, the growth rate of the startup will stabilize. So when computing terminal value, again, we have seen the statistic that 90% of startups don't make it past 3 years. So can using terminal value make the right sense for startups? The answer may be no. So while income approach is very commonly used across all valuations, it may not be used in its simple form for startups. Next, moving on to the asset approach. Now, asset approach is the NAV approach. Now, NAV, this is more of a sum of parts, you can say, where the current realizable value of all assets is calculated. And again, why not for startups? Because as much as you may say they are bound to fail, or there is a chance for them to fail, they are still operate under a going concern assumption. And the startup approach is that there are negligible assets. Startups don't believe in owning. They even don't have office spaces. Co-working spaces are the trend. So they have negligible assets. So the NAV approach may not work. And a large chunk of assets are in their intellectual property, which are intangible assets. And it is difficult to value the intellectual property under this approach. Moving on to the market approach. Now, again, this is the easiest method of computation. And this assigns the value based on how comparable companies are doing and their statistics. So say you can see a comparable company and take their P ratio, or you can take their various multiples. But these comparables have to be adjusted for company specific differences. Now, there is a reason why this approach does not squarely apply for startups as well. Firstly, disruptors, they have something different to do. Startups, when they are formed, the only purpose of them is to do something different, to make something different. So if you tell a startup that you are comparable to something, it is sort of an insult for them. Generally, they do not have any established competitors. Now, every startup is fighting up their own battle. So they do not have any established competitors to look for. And so using multiples of any competitors may not give the realistic results. Again, they have different risks. Some are bootstrapped, some are heavily debt funded. They have different growth trajectory. They have different characteristics. And however, there's a caution point that in advanced funding rounds, this market approach is being used. It's being used in a different way, which we'll come to later. So now this begs the question, how do we value startups? Now, what we have seen is in these traditional approaches, they somewhere fall short because the traditional value drivers like profits, cash flows, and quality of assets, these do not matter that much to startups. So the question is, how do we value them? Now, before we can understand, you can look at the valuation approaches for startups. We first need to understand what drives their value. So what are the value drivers for startups? Now, I've listed a few key value drivers. Now, the first one has to be product. Obviously, the product is what the startup thrives on. These are value drivers which the investors look for in the meetings, and the quality of value drivers determine the value of the company. So when you're looking at the product, you look at these questions: is it unique? Is it ready? And what is the customer response? So again, company which has a product will attract a higher value than a company whose product is just an idea or on paper. Then again, the management is a key value driver. Now, there's a statistic that more than half of the founders of unicorns are from IIT and IIM. Now, that does not mean in any way that to be a successful startup, you have to be from IIT or IIM. But from an investor's perspective, if someone tells them the statistic that more than half the founders are from IIT or IIM, they would look for people from IIT or IIM because that would increase their probability of their investment being a success. So because management is something which is like the credentials for your product. You may have the best product, but if there's a bad management, you would not be able to sell it well, and it will not be sustainable as well. So again, a balanced management is also necessary. So if you are a product-based company, so you may need to have a mix of engineers, graduates, and MBAs, and say finance professionals as well. So these all drive the value of the startup. Next up is traction. Now, we all have seen Shark Tank, and in that, while everyone explains the idea first, the next thing which the sharks look for is traction. They look what are the how well the product has performed in front of the customers. So traction is nothing but quantifiable evidence that the product actually works. Everything can look good on in theory, but does it actually work? This becomes a very key value driver. Customer reviews and after sales is also a very big part of traction, because that tells whether the customers have liked the product or not, or whether it is positive traction or not. Next is industry. Now, industry is a very key component, I would say. A company can only be as good as its industry, because industry directly affects the demand and supply from investors. Now, we can take an example of the edtech industry. If you have seen the edtech industry 1 year back, it was selling like a hot piece of cake. Everyone wanted to get a piece of the edtech industry. So that industry was very lucrative. So other value drivers may have taken a backseat while investment. Now jump to today and look at the same industry today. The edtech, there are massive layoffs going on. There are massive cost cuttings going on. There is some news or the other every day about how the industry is not doing so well. So today the industry's demand and supply is bad. So even a company with other good value drivers would fail to attract a better valuation today, just because the industry is not doing well. So an industry plays a very important role. So again, the industry includes all these logistics, distribution channels, customer base, and government regulations. These all determine how well the company can be. So it becomes a very key value driver. Next up is competition. Now, competition again is I would say it's like a two-edged sword. So again, there's no escaping the first mover advantage. But in the long run, it is always the product which will win. So Google was not the first search engine, Yahoo was. Facebook was not the first social media platform, Orkut or MySpace, they were the first social media. Apple did not make the first computers, so on and so forth. So competition, but when you're talking about startups, it sort of becomes like a catch-22 situation, because if you have competition, the investors say they demand that you differentiate yourselves, and if there is no competition, it would be much more difficult to convince them of the value. So it is sort of a catch-22 situation, but it is an uphill task, but no one said it would be easy.
Recording
news
in
report was
progress.
that one of the key reasons was that Baiju had really aggressive revenue recognition practices. Now, suppose if they were selling a course, educational course, which was for 3 years and which was cancelable in the second and third year, they were recognizing the entire revenue in year one itself. So that is a pretty aggressive revenue recognition practice. And it just shows how important revenue is for startups, which means it is really important for investors as well. So now to drive the point, every startup is unique. So there is a lot of subjectivity in each value driver. And that is why there is a need to introduce a few standardized methods so that there can be some comparability. So it's a very dynamic field. There is a new method for valuing startups. It's not, they may be a similar approach, but the methods are different because variables can change across companies. Now, who should know how to value a startup? The first two are very simple. Professionals, as professionals, we should be able to advise our clients as to how to value it. As investors, if we are planning to invest in a company, you should know how to value the company. The third is the most important one, the founders. The founders themselves should know how to value their own startup. So even they should be, in my opinion, they should be better than professionals in knowing what the market conditions are and how any good startup founder would be knowing what is happening in the startup world, and especially in their own domain. So valuation as a subject is very important for the founder himself as well, himself or herself. So let's look at common valuation approaches. Now I use the word approach very carefully because a method, when you say something is a method, it becomes very rigid. But as you know, startups are unique. So an approach is more of a guideline on how to value the startup. Now we'll be looking at a few approaches, which are the most common ones. The first is the Berkus approach. Now this was made by VC capitalist Dave Berkus in the 90s, I would believe. He's a famous American VC. And this is specifically used for pre-revenue startups only. Now, suppose you're a pre-revenues, you have not made any sales, but that does not mean that the company should not have any value. So what Berkus did is he found 5 key value drivers, and he said, let's rate the company based on each value driver. So there are 5 value drivers, say idea, team, prototype, relationships, and production and sales. So an arbitrary value is assigned by the valuer to each factor. So say, and the value has to be capped at $500,000. So since there are 5 key value drivers and the value is capped at 500,000 for each, the total revenue of the startup pre-revenue is capped at 2.5 million under this approach. Excuse me. So let's take an illustration to see how this works. Now let's look at a value driver, which is idea. So let's say we are valuing a startup which under this method. So does it have a good idea? Yes, it's got a pretty above average idea. So we have assigned a value of 275. Now, is the prototype ready? Yes, it's more than half of it is ready. So we have assigned, say, a value of 300,000. How is the team? The team is pretty above average as well. So we have assigned this value. How are the relationships? Now, relationships are a very good value driver as well because they determine how well the product will do. How many relationships do you have with the regulators, with competition, with senior professionals, etc. So in this product, in this company, the relationships are, the management has good relationships. So the higher value of 400,000 is assigned. And production rollout, no, the company has hardly done any production. So you, as a investor, I don't know whether the company will be able to match its commitment or not. So we have assigned a lower value of 100,000. So a total of these values comes to a 1.4 million. So that is the valuation under the Berkus approach. Now, what are the key takeaways of this approach? The first is these 5 value drivers are trying to capture the value of the startup. And however, the biggest criticism of this approach is the subjectivity which is involved in valuation. So, but a point about subjectivity is, see, valuation as a subject is very subjective. It is totally dependent on who is valuing. So, but what this approach does is it gives a starting point to negotiate. So it will ensure that, so say today I'm saying the value is 1.4 million. So tomorrow any learned person will not say, no, let's start at 1 million. It will not be like a fish market. So what happens is the person will say, okay, see, the idea is not so strong, so let me just put it at 250. So what gives a framework as to where you can negotiate and how to value a company, and this ensures that there is some method which remains. Having said that, Barker's approach is very, as you can see, it's very simple to do, and it's used by founders mostly. It's a very uncomplicated tool. Now moving on to the cost to duplicate approach. Now, I think a year or so back, there was a very famous web series called Scam 1992. It was based on the Harshad Mehta stock market scam. So in that, there's a scene where Harshad Mehta goes on to meet the chairman of Polo Steel, and he tries to talk about valuation. Now he ends up explaining the cost to duplicate approach. So I would let Harshad Mehta discuss it.
Before we enter, I want to warn you that my dad is very old school. Lala, old school हो या new school, सबके syllabus में एक subject common होता है, profit. और वो मेरा favorite subject है. पिछले क्वार्टर में आपने 20 करोड़ से भी ज्यादा का प्रॉफिट किया, और उसके सामने डिविडेंड पे आउट इज ओनली 40%. काफी टाइम से आपकी कंपनी के सारे आंकड़ों को नजर टिका के बैठे. What is the current value of your share?
It touched 28.
Where do you intend to go by the year?
Minimum double.
Tell me, when did you commence your business?
1972.
Long time. काफी कुछ इन्वेस्ट किया है. Your passion, your time, all those sleepless nights. तो 19 साल पहले इस कंपनी को बनाने के लिए आपने कितना पैसा डाला? मुझे बताइए, उतने ही पैसे में आज अगर ऐसी कंपनी बनानी हो तो बन जाएगी. तो पोलो जैसी कंपनी को खड़ा करने के लिए आज कितना पैसा डालना पड़ेगा? Now that's the real value of your company. देखिए, कुछ लोग शेयर मार्केट में किस्मत पे विश्वास रखते हैं, पर मैं किस्मत में नहीं, कीमत पे विश्वास रखता हूं.
So that was about the cost to duplicate approach. Now, as the name itself suggests, it says cost to duplicate. So how much cost would it incur to actually duplicate the company, the startup being valued? So again, it considers all the costs which have been incurred till date to have the startup where it is today. All expenses like product development, R&D, operating expenses, capital expenditure as well. So this approach is based on the expenses which have been incurred. A very obvious criticism is that this ignores one very key word of startups, that is the word future. Now, there is no focus on the future revenue projections and how much value the startup will derive. Now, a majority, as I said, startups are disruptors and their focus is only on the future. So when they focus on future and this approach looks at the past, so this is a big criticism. And again, this approach does not value the IPR as well, right? Because a lot of their value of startups is in the intangible property. But I'll give you a practical example where this approach is actually used. So suppose the startup which you're valuing had started at a time where the industry was in a very nascent stage. And today, when you're valuing, the industry is in a maturity stage. It's pretty matured. So there are a lot of barriers to entry. So in that case, one can argue that my real value is the cost to make this company like it today. So these are some practical ways where this approach is used. Now moving on to comparable transactions approach. Now this approach again is very, very close to traditional market approach. And there's a lot of psychology behind this approach. So I'll give you a short example. So till 10th standard, I used to get a lot of good marks, like 90, 95% in school. So, but once you went to, I got good marks in 10th and I went to junior college in NM college. And in NM college, 11th standard, we took it a bit lightly. So in my first exam as only, I got 54%. Now that 54% is a shock for someone who's always been in 85, 90, 95. So when I went home, my parents asked me, what happened? Why is it, how many marks did you score? So my answer was not, I got 54 marks. My answer was, see, the paper was really tough. My friend, he got 45%. My other friend, he got 50%. But I have got 54%. Now this is the exact psychology. It did work, by the way. And this is the exact psychology where the comparable transactions approach comes. It says how much were similar startups valued at. And this is what it seeks to answer. Now this has become very famous because there's a lot of increase in M&As in the past decade. So there are a lot of comparable transactions. So this is commonly used to value startups. And again, like the market approach, you need to factor in the differentiating qualities as well. Now, these can be technologies, intangibles, and say amount of debt, industry penetration, many factors. Now, we'll take a very simple example of this approach. Say Bunty Private Limited is a B2B logistics startup. Just last week, it got acquired for 560 crores. Now you see that at the time of acquisition, it had 24 crore active users. And today, Bubbly Private Limited comes to you and says that please value us. And it is obviously a newer B2B logistics company, and it has 1.75 crore active users. So what do? You look at Bunty Private Limited. You see the cost per user as one metric. See, a cost per user comes out to be 23 rupees, which is 560 crores divided by 24 crores. So approximately 23 rupees is the cost per user. So that is what you do simply. You just look at the active users of Bubbly Private Limited, which is 1.75, and just multiply it by 23. So that gives a approx valuation of 40 crores. Now this is how simple this approach is. And this is why it is so famous as well, because it is pretty easy to compute. It does not have too many inputs. It does not have too many variables. The next one is scorecard valuation approach. The scorecard valuation approach is, again, it is used by pre-revenue businesses. It builds on the Burkus method, which we saw, which had 5 drivers. This has 7 drivers. And what it does is it compares the startup value to a benchmark valuation in the industry. So first we have to find the average pre-money valuation of comparable companies in the industry. And then they have to be evaluated in front of 7 qualitative factors, which are strength of the team, size of the opportunity, product, competitive environment, partnerships, need for additional investment, and others maybe which are specific to a startup. Now, each of them are assigned weights. Now, if you remember in the Burkus method, all 5 of them had similar weights. But here the weights are assigned by the standard approach, and these weights are adjustable as well. So if for a particular startup, you say the team is less important than the service, so you can give it 10 and you can give the service as 15%. So these can be played around with. And after this has been evaluated, then you have to compute a factor to get the amount of valuation. Now we'll try to take it by way of an illustration so that will be easier to understand. Now see a comparison factors. These are the 7 factors. And for this example, let us assume that the ranges which are given in the standard approach remain the same. So we can change this, but for this example, we are not changing it. Now, what has to be seen is compare the each factor to the industry. So, strength of entrepreneur in our target company, I think that the strength of the entrepreneur is much better than what is in the industry. So I will give it above average, above 100%, and I will give it a rating of 125%. Now I will multiply this weight and this rating and get a factor of 0.375. Similarly, this has to be done for everything. I think that the size of the opportunity is massive, so I give 150%. But at the same time, I think that they don't have adequate sales or partnerships. Their competitors have it better, so they'll assign 80% to this. Now, once you get the factor for each value driver, you have to add it up and you get a total factor, which is 1.07. Now, this 1.07 has to be multiplied by the benchmark valuation, which we had computed earlier. Now, once you get that becomes the pre-revenue valuation of the startup which we are valuing. What are the key takeaways from this approach? Firstly, it is very much more detailed than the Burkus method. The Burkus method had just 5 drivers. This has 7. And it gives more flexibility because you can adjust the weights. At the same time, it suffers from the same limitation of subjectivity. While assigning the weights, as well as the comparison factors, it suffers from subjectivity. So it will definitely be different for everyone. But again, one more point is the benchmark valuation. Now, as we know, all startups are fighting their own battle. So is taking the valuation of another startup as the benchmark the right move, because their own valuations are haywire. So there are a few bit of pros and cons in this factor as well. Now moving on to first Chicago approach. Now remember when we discussed about the DCF approach and said that DCF approach does not factor in that term that startups will not live beyond, say, may not live beyond 3 years. So this approach tries to correct that shortcoming. So this is applicable for post-revenue startups only. So what is to be done is valuation has to be done in 3 or more scenarios, 3 being most common. One is the worst case scenario, the one is the average normal case scenario, and the third is the best case scenario. So you have to work out valuations in these 3 scenarios, and then work out a probability for each scenario to happen. Say, I think the normal case scenario, there's a 60% chance that the normal case scenario will be the actual scenario. Obviously, the normal case scenario has to be the highest weightage among all 3. And once you determine a probability factor, you have to multiply it, and you can get the valuation of the startup. Now, let's take a simple example. So say, I believe that the normal case valuation under normal case would be 500 crores. The valuation under best case would be 800 crores. Worst case would be 300 crores. And I have assigned these probabilities to each case. Now I multiply this and get a sum product which is 545 crores. As you can see, the weighted valuation should be closer to the normal case scenario. But the biggest takeaway is that it factors all best case and worst case as well. So it plays more of a mathematical gamut, like playing with probabilities. But at the same time, it makes it far more complicated. So it was trying to resolve the one shortcoming of DCF, but it ended up creating its own shortcoming, which is that you have to do valuation 3 times. And to do 3 times, you have to estimate cash flows 3 times. So this makes it a bit more complicated. And again, there is a subjectivity involved in estimating the probability of each scenario. Now, moving on to the most famous valuation method for startups, which is the venture capital approach. As the name suggests, it has been made famous by VC firms themselves. It involves a reverse calculation. So what the startup looks at is how much will it earn, should it earn for it to make it worth my while. So the investor will think in his own terms. So the investor wants a certain return from this investment, and that is how they will value the company itself. So as you can see, the focus shifts from the startup into the VC firm. And I'm not saying it is right or is it wrong, but that is how the approach is. So it calculates how it can invest today based on how much return the startup will give. Now, once we take an example, it will be easier to understand. So let's say there is a startup, Geeth Private Limited. It wants a 2 crore investment from a VC firm. Now, that is all you know. So as a VC firm, what it does is it asks Geeth Private Limited, give me your forecasted financials. So it gives after 3 years, the EBITDA will be 8 crore rupees. Now, after 3 years, the VC firm says, I want to exit after 3 years. I can exit by way of an IPO. Maybe I can exit by way of Tata acquiring or a Reliance acquiring. So at the time of exit, I will estimate that there will be a 10x EBITDA multiple. So after 3 years, my valuation of Geeth Private Limited would be 80 crores. Now comes the real part of the valuation. The investor says, see, looking at this entire risk, looking at the entire competition, looking at the market scenario, I believe what will make this investment worth my while is a return of 100% per annum. I want a return of 100% I want my investment to double every year. So what the VC will do is it will discount the valuation of 80 crores. For 3 years, the discounted valuation will come at rupees 10 crores. Now that is the post-money valuation. So post-money valuation means after the money has been received by the startup, the valuation is 10 crores. So pre-money valuation is nothing but the post-money valuation minus the round size, which is of 2 crores. So the post-money valuation is 10 crores. Now the startup will say, okay, so if I have to give 2 crores out of 10 crores, that means I should get a 20% stake. So this is how this entire approach works in reverse. And this entire thing forms a part of the negotiations, because as a investor, you want to have the highest amount of stake. As a startup which is getting funds, you want to let go the least amount of stake. So what are the key takeaways? Firstly, as you saw, it focuses on what the investor wants and not what actually the startup is doing. In a way, you can say it is a win-win, because the startup, they just wanted rupees 2 crore. They get that 2 crore. And the investor, he wanted a return of 100% per annum, so he's getting that return. So it's a win-win in that format. But at the same time, this approach does not consider the risk of the startups. Now, the VC is only considering the amount of return based on what he wants, or what he or she wants. They don't look at what the startup's actual cost of capital is, and they don't look at the risks which the startup has, this entire multiple. So as I said, the focus has shifted from the startup onto the investor. But again, this is a very famous approach. Most VC firms use this approach because it is very simple to do. Now, I gave you a very simple example, but they just take 5 minutes to make a financial model out of this. And that makes it really easy to do as well for VC firms. Now, enough about numbers. Now, it's time to look beyond numbers and actually see where the valuation of a startup lies. It is in the story. So I'd like to quote Professor Ashwath Damodaran, who's widely regarded as the dean of valuation. And he says that if all you have are numbers on a spreadsheet, you don't have a valuation, you just have a collection of numbers. And that is true, because all the types of valuations you see on public platforms like LinkedIn, they are not valuations, they are financial models. A true valuation cannot be made without looking at the story. So let us see the importance of a story. Now, I'll take a very practical example. Suppose you have to decide whether to invest in Rolex or not. And you are on the market as an investor. So there are obviously a lot of calls coming in from investment bankers. See, so 3 investment bankers are coming today to pitch separately. So you must decide, looking at their pitch, which is the best and which will help you make a decision. So there are 3 pitches. First one, let's see the first pitch by the first banker. He says the earnings of Rolex are slated to grow at 9.5% for the next 5 years before dropping down to the GDP growth rate. The operating profit margin will be 43%, NP margin will be 16%, and it will be able to generate for the next 5 years.
In progress.
The same need for exclusivity also allows Rolex to earn an above average profit margin of 43% and maintain stable earnings over time, because the client base of Rolex is relatively unaffected by the highs and lows of economy. Now, as an investor, if you look at the first pitch, this gives you all the data you need to be, this gives you all the numbers you need, to be honest. But what will you do after looking at this? You will see it gives me 2.54 for every rupee. So I will look for other investments which will generate me, say, 3 rupees for every rupee invested. So pitch 1 will not inspire the investor to invest in the company. Looking at the second pitch, it is a very inspirational pitch. It tells you about the story of Rolex, but it does not help you reach a conclusion as well. You do not know whether the numbers are sound or not. Now, if you look at pitch 3, here everything is tied up with the numbers. The story gets tied up with the numbers. Now this pitch makes sense. Now you can get a better perspective of what Rolex is actually doing. So this is the hallmark of a good valuation: merging storytelling and the numbers. That is what makes a good valuation. That makes sense to the investor. That makes sense to any user of the report. So how do you actually merge this? While it sounds good to say that, but how do you actually do it? So Professor Ashwath Damodaran has given a brief 5-step process for this. So first he says is develop a narrative for the business which is being valued. First, you have to start with the story. You have to start with what the future story will be, or what the future story can be. Now the second step is to test whether it is possible, plausible, and probable. Now there are a lot of possibilities. Is there a possibility that I will win a lottery of 1 crore tomorrow? Yes, it is possible. But is it plausible? No, because I have not bought even a lottery ticket. So it's not plausible. but say suppose I go and buy a lottery ticket, but is it probable? No, it is highly improbable that the narrative will actually work. So that is how you have to test the narrative, whatever is being developed. Now comes the most crucial step: convert the narrative into a value driver. Now, just as we saw in the case of Rolex, if the narrative was that it's catering to an exclusive club of individuals, that is why the revenues will grow at a lower rate of 9.5%. That is a revenue is a driver of value. So that is how you convert the narrative into a driver of value. Next, you connect the driver of value to the valuation. So suppose it's talking about revenue. So let's go back and see. So as the first line says, due to the need to maintain its exclusivity, the revenues of Rolex will grow at a low rate of 9.5% for the next 5 years. This is how you connect the narrative to the driver and the driver to the valuation. And again, this is not a perfect process. So always it is advisable to keep the feedback loop open, speak with more experienced people, speak with more people. So, and then you can revise the narrative. You can then revise the effect of the narrative on the value driver. All in all, a real good valuation is not just a collection of numbers. That is a financial model. A valuation is story and numbers merged together. So to wrap up, startups are disruptors on their core. I've said that from the beginning of this presentation. It is difficult. There is no standard method to value it. There will be a new method by the time I'm done presenting this. And again, it is a scientific art. It is again not something which is totally arbitrary. There is a method. There is a method. It may seem like madness, but there is a method. And value drivers for startups transcend, I would say. They rise above the traditional indicators like cash flows and profits. So there are no shortage of methods for valuing a startup. So at the same time, as you saw, there are so many approaches and methods. But what you have to keep in mind is a valuation is much, much more than the method of valuation. Now, there are a lot of analysts and investors who spend hours fussing about the method of valuation being used. But there is something which is more important than the method. That is actually merging the story and the numbers. Once you can develop a narrative and then value a startup, you will be able to find the true value of the startup. And that is what it is. It is a cocktail of the story and the numbers. So with this, I would like to wrap up and thank you very much. I'd like to express my sincerest gratitude for giving me this opportunity. And if there are any questions and time permits, we can take them, or we could take the questions offline as well.
I request all the joinees present here to put forward any questions they have with this session. Also, see Vijay Kumar Puri sir, this was such a great session with such lively examples. I'm sure everybody must have enjoyed it. We have some questions coming up, sir, on the way.
Sure.
Bhavani Shankar Paul from Kolkata asks you, sir, please give us some more practical examples.
Practical examples in which method or in which context?
We'll put that up.
So we can
Bhavani
connect
Shankar Paul, please mention in which sector would you like, sir, to give some more practical examples?
We can absolutely connect offline for this as well. So my coordinates are on the screen. We can discuss.
Also, Amit Agarwal from Surat asks, sir, can you show us any real valuation done for any startup and how it is valued?
So absolutely. Thanks for the question. Firstly, any valuation which is done, I believe what you're asking for is a financial model, because you can't show a valuation. You have to explain a valuation. You have to see how you arrive at each number. There are hundreds of financial models available. You can Google it. You can find it on LinkedIn. There will be financial models for various startups as well. However, if you want to actually see a valuation done, it is better to read a valuation report. So most startups which are raising funds have their valuation reports in the public domain on their websites. And it is better to read that valuation report to get an understanding of how it has been valued.
Aishwarya Kadam from New Panvel asks, which is the most used approach for valuating startups?
If you're investing firstly, thanks for the question. And if you're investing as a investor, as a VC firm, the venture capital approach is most commonly used. That is seen day in, day out. everyone uses the venture capital approach. Second, I would say is the comparable transactions approach because of how easy it is. And third, I would say is the DCF approach with its modifications.
Any more questions? Amrit, please see if we have any more questions regarding this session. So I'm sure this webinar proved to be very insightful to everyone present. I would like to extend my heartfelt thanks to Advocate Manas Kumar Chaudhary, sir, and CA Vijay Kumar Puri, sir, for making this webinar a great learning for us all. I would like to also thank our chairman, CA Dr. Rajkumar S. Adukia, sir, and Vice Chairman, CA Gyan Chandra Mishra, sir, who attended this webinar and enlightened us. So this is CA Gunjan Jain signing off for today. Hope you all enjoy health and success in all your future endeavors. Thank you. Amrit, are we offline?
Yes,
Recording stopped.
Thank you, CA Gunjan. That's a very
Thank
nice
you.
moderation.
Thank you, sir.
Thanks a lot.
Thank you, ma'am.
Thank you, Krishnakant. Thank you, Amrit.
Thank you,
Gunjan.
thank you, Tech Support, for your help. A really good session.
Yeah.
How many people were live at the moment? Or were they live? Sorry?
380.
380. That's nice.
Yeah, that's a good number to come up with
No,
online
yeah.
session.
I think back in May or April or May, when I was moderating one session, so that session was on cryptocurrency. That session had around 1,000 people because cryptocurrency is like the hot topic always.
Also, that was the time when people were engaging in online webinars,
Exactly. Absolutely.
the COVID and things like that.
Yeah, because people were engaging. That's true. Absolutely. So
anyways, great session, I heard. So you are from Mumbai?
that's right. I'm from Mumbai. You are from Guwahati, right?
Guwahati.
I read on that. That's very nice. So we'll definitely connect offline as well.
Okay, thank you.
Thank you. Bye bye.